Hello, my name is Mara O'Keefe, and I'm grateful for your time and attention today as I discuss an important topic. Sexual misconduct, specifically sexual harassment, can occur in myriad school system settings and affect staff and students alike. In order to foster a safe, welcoming educational environment and workplace for all Wake County Public School System community members, it is important for you as a staff member to understand your role and responsibilities in identifying and responding to potential sexual misconduct. By the end of today's presentation, I hope to achieve 3 goals. First, you should understand what conduct is considered sexual harassment. You must understand what this term means and be able to picture the conduct it encompasses in order to support a safe, hospitable workplace and school environment. Second, you should understand your obligation to report potential misconduct, specifically sexual harassment, but also related improper interactions among staff and students of a sexual nature. Third, and finally, you should know where to go with questions. I cannot possibly discuss every context in which sexual harassment may arise, but by the end of our time together today, you will know whom to contact when you have questions about whether misconduct constitutes sexual harassment and what conduct you must report. Sexual harassment is a term widely used but sometimes misunderstood. Let's dispel some common misconceptions. It's only sexual harassment if it impacts women. False. Sexual harassment can impact someone irrespective of their gender. It's only sexual harassment if there's physical contact. Again, false. Sexual harassment does not require any physical contact, and in fact captures a much broader field of conduct that we'll discuss shortly. If no one sees the harassment, I'm out of luck and nothing can be done. Again, false. Allegations of such misconduct are investigated pursuant to Board Policy 1720 and/or the Title IX complaint procedure and require investigators to consider relevant evidence. That there are no witnesses to the alleged misconduct does not mean there isn't relevant evidence to be weighed. Sexual harassment is something that only happens between a supervisor and an employee. Again, false. Sexual harassment can occur between and among students, employees, volunteers, and contractors. While some sexual harassment includes a power differential, like that between a supervisor and employee, other forms of sexual harassment do not. For example, sexual harassment can occur by a student toward another student, a student toward a staff member, by a staff member toward a student, or by a staff member toward another staff member. Sexual harassment barred by the Title IX regulations means conduct on the basis of sex occurring in a school system education program or activity and in the United States that satisfies one or more of 6 specific conditions. First, an employee of the school system conditioning a provision of an aid, benefit, or service of the school system on an individual's participation in unwelcome conduct. Second, unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies the person equal access to the school system's educational program or activity. Third, sexual assault, including rape, statutory rape, fondling, and incest. Fourth, dating violence. Fifth, domestic violence. And sixth, stalking. Prohibited sexual harassment in employment includes, but is not limited to, unwelcome conduct which is either of a sexual nature or is directed at a person because of the person's sex, when submission to the conduct is made either explicitly or implicitly a term or condition of a person's employment, the submission to or rejection of such conduct is made the basis for decisions affecting a person's employment, or the conduct has the purpose or effect of unreasonably interfering with an employee's work performance or creating an intimidating, hostile, or offensive work environment. Now that we've defined sexual harassment, take an opportunity to test your knowledge. True or false? It's only sexual harassment if the actor intended it that way. False. Intent is not a required element of sexual harassment. In other words, just because someone didn't intend to commit sexual harassment does not mean they haven't done so. That a respondent alerted to alleged misconduct didn't mean it that way does not mean the conduct in question does not actually constitute sexual harassment. True or false? It is possible for the harasser and the victim to be the same sex or gender. True. Harassers can be male or female, and victims can be male or female. What matters is that the conduct meets the definition of sexual harassment contained in Board Policy 1720. For example, a female student inappropriately touching another female student may commit conduct that amounts to sexual harassment. Now that we've defined sexual harassment and dispelled some common misconceptions about it, let's discuss what this misconduct may look like in practice. Now, for some examples of sexual harassment. A teacher conditions improving a female student's grade on the student providing after-school back rubs and engaging in texts with sexual innuendo. The student complies to bump up her grade but is ashamed and feels uncomfortable going to school. This is sexual harassment. The teacher is promising a benefit, a better grade, in exchange for the student engaging in unwelcome conduct of a sexual nature. A male basketball player who is team captain repeatedly calls the team manager, a transgender student, by cray instead of their preferred pronoun, they, and encourages other students on the team to follow his lead by labeling the manager's clipboard and equipment bag with this term. This likely constitutes sexual harassment. The team captain and his teammates are treating their fellow teammate differently purely on the basis of sex by mocking him for his transgender status. Assuming the conduct is determined to be so severe, pervasive, and objectively offensive that it denies the student equal access to participation on the team, it constitutes harassment prohibited by Title IX. A mentee makes flirtatious comments to her mentor, asking about his sex life and dating history. The mentor feels uncomfortable at work, in part because their offices are adjacent, and as he's unable to work remotely, feels like he must take sick and personal days to avoid this colleague. This sounds like conduct that violates both Title VII and Title IX. The mentee is engaging in unwelcome, sex-based conduct toward her mentor that is objectively offensive and that is seemingly so severe and pervasive that it's making the mentor uncomfortable at work, so much so that he's not coming to avoid working with this colleague. The fact that the mentee is coming on to the mentor rather than the other way around does not mean that this is not sex-based harassment. One effective way to foster a safe, supportive environment where all students and staff feel comfortable is to be mindful of your own behavior. To that end, here are some examples of conduct that, alone or in concert with other relevant facts, may amount to sexual harassment. First, physical contact, sexual in nature, even when it's not intended that way, such as sitting on laps, slapping one's behind, rubbing one's body. Second, verbal and non-verbal communications made on the basis of sex. For example, ongoing comments on the appearance of someone's body, looking someone up and down, or spending an inordinate amount of time with someone and becoming overly familiar. Rely on your own sound discretion when making decisions about your conduct toward others in various school settings. I want to focus for a moment specifically on conduct towards students that may create fertile ground for sexual harassment. Spending time alone with a student in isolated, non-public areas of campus, such as behind closed or locked doors, before school, or while the student should be in another class. Offering students rides in personal vehicles. Buying gifts for students or giving them special treats. Taking students to the movies or spending too much time where students congregate. Engaging in non-school related communication with a student. All of this conduct is risky, and beyond amounting to sexual harassment in certain circumstances, it may suggest engagement in employment-student relationships barred by board policy. More on that in just a bit. Let's pause for another brief opportunity to test your knowledge. I ask that you consider whether the fact patterns described next include conduct that constitutes sexual harassment. In this case, a male supervisor called a female employee stupid on a near daily basis. He yelled obscenities at other female employees. He also got angry with a male employee, but the supervisor never called him stupid to his face or directed vulgarities toward the male employee. Is the supervisor just a jerk, or is this sexual harassment? The court that reviewed these facts concluded that the male supervisor's conduct was sexual harassment. The court reasoned that the supervisor's verbal conduct toward the female employee was sufficient evidence to establish a hostile environment because female employees were the primary target of the supervisor's remarks, and the repeated nature of the remarks had a demeaning and degrading effect. What about this case? Here, a successful college coach of a women's soccer team talked to his female players about their sex lives. He accused some of them of being promiscuous, asking one of them about the size of her boyfriend's genitals, and mocking a lesbian player by referring to her with a male's name and asking her why she didn't like guys. The Fourth Circuit Court of Appeals held that the coach in this case had created a hostile environment because his statements amounted to a sexually charged atmosphere where players expressed feelings of humiliation and discomfort. Let's look at a fact pattern involving students. Student SM is 8 years old and has been diagnosed with Down syndrome and attention deficit hyperactivity disorder. He served in a classroom designed for students with moderate intellectual disabilities. An instructional assistant reports that this student, SM, reaches up her dress to touch her private parts over her clothes almost every day, and on one instance even grabbed her bottom. Experts who testify in the subsequent case opined that this student's behavior is not uncommon for a child with his age and specific disabilities, and further, that he doesn't have the ability to distinguish between the sexes. The court that reviewed these facts ultimately found that there was no hostile environment because there was not sufficient evidence that the unwelcome conduct by the student occurred because of the teacher's sex. Again, experts in the case testified that the student could not discern between another's sex as a result of his disabilities. And thus, although the conduct was inappropriate and made the teacher feel uncomfortable, it did not amount to sex-based harassment that established a hostile environment. An 8th grade student joins a high school book club led by Mr. W. Mr. W makes sexually suggestive comments to students during the meetings. Student is assigned to Mr. W's class at the start of 9th grade. The teacher continues making sexually suggestive comments, directing more and more of them to student. Student starts skipping Mr. W's class, then stops attending school altogether until the semester ends and she's no longer in Mr. W's class. This example is based on a Supreme Court case analyzing the school system's responsibility to respond to notice of sexual harassment barred by Title IX. For our purposes, though, the question is whether this conduct would amount to sexual harassment under Title IX. It would. The teacher's unwelcome conduct is based on the student's sex, and by a reasonable person standard, it is so severe, pervasive, and objectively offensive that it effectively denies the student equal access to her class. After all, she started skipping classes specific to avoid this teacher. Now, let's turn to an example involving students. MO, a male student, is older than JD, also male, but both are in the same classroom. MO occasionally teases JD, calling him gay and joining other students in labeling him a snitch. On one occasion, MO exposes his genitals to JD in the school library. Months later, during a dance activity in class, MO grabs JD and makes humping gestures toward him. JD's parents report concern that MO has also routinely been making sexual remarks to JD. 3 female students corroborate the parents' account. Administrators, though, check in with JD and find that he routinely says he's having a good day. This fact pattern is based on a case arising in Maryland. The court's focus was whether the school system had failed to protect JD from sexual harassment in violation of Title IX. But for our purposes, the question is simply whether this conduct would constitute a hostile environment. Indeed, it may. MO's conduct toward JD is seemingly based on his sex. Though JD has reported that he's having a good day, objectively, this conduct is offensive. If I were a staff member observing this conduct, I would report it to the appropriate Title IX coordinator so that the other elements of a hostile environment, specifically whether JD himself finds the conduct offensive despite his comments to administrators, and how this conduct is impacting JD, can be properly considered. True or false? If my conduct doesn't constitute sexual harassment, then I have nothing to worry about. False. All employees have a duty to behave in a professional fashion with honesty, integrity, and fairness. Failing to abide by this high standard could subject you to disciplinary action. A common misconception about sexual harassment is that if one's conduct doesn't meet the definition under Title VII or Title IX, then the employee behaved properly. This is simply untrue. Conduct that doesn't rise to the threshold barred by federal law may nonetheless be inappropriate and fall short of the standard of conduct expected of employees. As a result, such conduct could lead to disciplinary action, even though it does not constitute sexual harassment. True or false? One incident of conduct alone isn't enough to constitute sexual harassment. False. Remember the definition of sexual harassment prohibited by Title IX and Title VII. Even one incident of misconduct, an assault, a single verbal exchange, could constitute sexual harassment. Now that we've explored examples of sexual harassment in various contexts, let's focus on what you need to do when you observe or learn of conduct that may constitute sexual harassment. All school system employees or members of the Board of Education who have actual knowledge of sexual harassment or allegations of sexual harassment occurring in the education program, any activity of the school system, or the work environment must report that information immediately to the appropriate Title IX coordinator. But what constitutes actual knowledge? Actual knowledge includes the following: any report of sexual harassment, any conduct witnessed that could reasonably be sexual harassment, or any reason to believe that someone may have been sexually harassed. Out of an abundance of caution, you should always err on the side of reporting potential misconduct. Do not wait for the complainant to raise the concern him or herself, or for another staff member to notice. Do not pursue your own preliminary investigation first to see what information there is worth reporting. When in doubt, simply report it out. Consider whether in the following circumstances you would have any reporting obligations as a staff member. An instructional assistant overhears student Rebecca talking to her friend with concerns about another student, Ralph. She says Ralph has been staring at her and following her at school, even though they don't have the same class schedule, and that he's also following her around in their neighborhood. Rebecca says they dated, but that she broke up with him, and since then, Ralph has even been slipping notes in her locker, calling her a heartless bee. Rebecca's friend says if she's so nervous, she should just talk to a teacher. If you're the IA, what should you do? You should immediately report this to the appropriate Title IX coordinator, one of the coordinators in the Office of Equity Affairs who specialize in student Title IX matters. You should also report this to your supervisor, who can help support coordinating with Title IX to provide any additional information they may need to ensure Rebecca's needs are met and both students' rights are protected during any subsequent investigation. Consider whether you have any reporting obligations in this next case. A student writes a letter that she's concerned about her friend, who's another 15-year-old student. The letter indicates that the friend has been sexually assaulted twice, that the friend's mental health is suffering, and the friend had even talked about self-harm. The student gives the letter to a teacher who then gives it to a counselor. The counselor meets with the 15-year-old student and evaluates her mental health, but doesn't ask her about the references to sexual assault. Is there a reporting obligation? Yes. This example is based on a case in Florida in which 5 staff members, a principal, 2 assistant principals, a counselor, and a teacher were charged with failure to report sexual abuse. In that case, the charging documents referenced the fact that no staff members asked the student about the assault after receiving the letter, they failed to report the alleged assault after receiving the letter, and only asked the student about the assault months later and after she had attempted suicide. Even when they did come around to speaking with the student, they still did not report the assault to law enforcement because the assistant principal felt that a sexual assault had not actually occurred. Strict adherence to a when in doubt, report it out policy and understanding of your mandatory reporting obligations can keep you and the school system out of hot water in a comparable case. And while we're on the subject of reporting obligations, please remember that your reporting obligations extend well beyond conduct that constitutes sexual harassment. Let's review briefly some of your other reporting obligations. Board Policy 4040-7310 strictly prohibits romantic or sexual relationships between a student and an employee. Age doesn't matter and consent doesn't matter. This same policy imposes on all employees a duty to report suspicion of an employee-student relationship. So, if you have reason to believe that another employee is inappropriately involved with a student, you must report this to the superintendent or his designee, the Assistant Superintendent for Human Resources or Employee Relations, immediately. Please remember that failure to make this report can result in disciplinary action, up to and including dismissal. Under Board Policy 4020-40-7312 and state law, a school employee, contractor, or volunteer is also legally obligated to report to law enforcement when they know or reasonably should know of any of the following: a sexual offense, meaning any offense that relates to inappropriate sexual conduct with or involving a child, an offense that inflicts serious bodily injury or serious physical injury upon the child by non-accidental means, an attempt, solicitation, or conspiracy to commit or aiding and abetting in either of the above offenses, or misdemeanor child abuse. Misdemeanor child abuse means inflicting or allowing to be inflicted physical injury to a child by non-accidental means, or creating or allowing a substantial risk of physical injury to a child by non-accidental means. The misdemeanor child abuse reporting obligation would, for example, be triggered if a staff member left a mark on a child after non-accidental contact, a student complained of pain after allegedly being spanked by a teacher, or a staff member allegedly dragged a child by a limb across the floor. Remember, failure to report may result in disciplinary action and/or civil and criminal action. What if you still have questions? If you're someone with special obligations under Title IX, for example, an investigator or a decision maker, the Title IX coordinator will provide you with resources and materials on those obligations. The Title IX coordinators are also available to answer questions you may have about sexual harassment and your reporting obligations. Here is contact information for Title IX coordinators Sally Potofsky and Dr. Gia Hoke. Ms. Potofsky is the appropriate contact for allegations of sexual harassment by an employee, volunteer, or contractor. Dr. Hoke is the appropriate contact for allegations of sexual harassment by a student. Thank you for your time and attention during today's presentation.